Dear students, this is Naganand Edumudi. To get updates relating to shorthand, please subscribe my YouTube channel. My channel name is Naganand Edumudi. 5 seconds. Start. On 23/5/1991, the appellant lodged a private complaint before the Judicial First Class Magistrate for the alleged offence under section 138 of the NI Act, which was numbered as SC number 34 of 1992. After a full-fledged trial and upon appreciating the documentary evidence adduced on behalf of the parties, the trial court allowed the complaint as the appellant was successful in proving the case beyond reasonable doubt that first respondent committed an offence punishable under section 138 of the NI Act. Accordingly, the trial court by judgment dated 29/7/1993 convicted and sentenced the first respondent to undergo simple imprisonment of 3 months. Aggrieved by the conviction and sentence, the first respondent preferred criminal appeal 104 of 1993 before additional sessions judge. The learned judge, after perusing the records and on elaborate hearing by its judgment dated 7/7/1995, dismissed the appeal by upholding and confirming the judgment of the trial court. Against the said order, respondent preferred criminal revision 644 of 1995 before the High Court of Kerala. The only ground raised before the High Court was that the provisions of section 138 of the NI Act cannot be invoked as the appellant had not complied with the conditions in Class B of the proviso to the said section. Notice demanding payment of the amount arising from the two dishonored checks in question was on 4/5/1991, whereas the intimation regarding dishonor of the said checks was given by the appellant's bank on 8/4/1991. Therefore, the notice was beyond 15 days. Hence, in such circumstances, section 138 of the NI Act was not retracted and no offence was made out. The High Court, by its judgment dated 6/10/2003, had allowed the revision by reversing the concurrent findings of the two courts below, holding that the statutory notice was beyond the prescribed period as mentioned under section 138 of NI Act. Now the issue before us is, even though the first notice was issued by the appellant within time to the correct address of the first respondent, whether the High Court was right in rejecting the case of the appellant herein on the ground that second notice was issued beyond the period of limitation, that is 15 days from the date of receiving dishonor intimation from the bank under Class B of the proviso to section 138 of NI Act. Before devolving into the issue, it would be appropriate to reproduce section 138 of the Act. A bare reading of section 138 of NI Act indicates that the purport of section 138 is to prevent and punish the dishonest drawers of checks who evade and avoid their liability. As explained in Class B of the proviso, the payee or the holder of the check in due course is necessarily required to serve a written notice on the drawer of the check within 15 days from the date of intimation received from the bank about dishonor. It is explicitly made clear that under Class C of Section 138 of NI Act that this gives an opportunity to a drawer of the check to make payment within 15 days from the receipt of such notice sent by the drawee. Stop.